Tonight we have Gene talking to us about staying safe online, not going to jail, not getting sued, all that kind of good
Well,
stuff.
I can't guarantee that.
All right, thanks, Gene.
All right, thank you. So, I'm Gene Curry. As you can imagine, I'm a lawyer. And given the size of the group, feel free to just ask questions as we're going along. You don't have to, we're going to cover a lot of different topics, so you really don't have to wait until the end of the presentation to, if something strikes your fancy or you have a question, just go ahead and ask it. So, we're going to start with a caveat, and we're starting with a caveat because I'm a lawyer, and that's what lawyers do. So this is what the Supreme Court has recently said. The forces and directions of the internet are so new, so protean, and so far-reaching that courts must be conscious that what they say today may be obsolete tomorrow. And that was in 2017. And I don't know about you, but it really makes me feel great about the Supreme Court that by 2017, they recognized that the internet was new. But this statement contains a certain level of truth, which is that the legal institutions are not necessarily well organized to address the rapidly changing environment that is the internet and the legal issues that are raised, which each year it seems like there's something new that people hadn't thought about before, and there's no legal answer that's readily available. And so things will change, and what was good advice a few years ago is probably not good advice today. This is all good advice, though. Okay, so the first thing we're going to talk about is copyright. And copyright is important if you are doing any kind of web development, posting any kind of content. And what copyright is, it's a set of rights that the creator of a work, and we'll talk about who a creator or an author of a work is, has. And those include the right to profit from the work. The most important one probably is the right to control copies of the work, to make what are called derivative works, and to perform the work. And copyright doesn't protect ideas. It protects content, the expression of an idea. And it protects that content when it becomes into a fixed medium of expression. So, if I were doing this presentation this evening as an interpretive dance, that could be copyrighted. However, it would have to be put into a fixed medium of expression. Fortunately, Gabe is doing that. Fortunately for you, I will not inflict my interpretive dance on you. But it only protects the expression. So Ron Chernow wrote a superb biography of Alexander Hamilton. The idea that Alexander Hamilton rose from poverty and obscurity in the Caribbean to become one of the most influential of the founding fathers is the idea. You can't protect that idea. So when Lin-Manuel Miranda was on vacation and he read Hamilton's the biography that Chernow wrote of Hamilton, he got the idea of turning that into a play. So he wrote a play about the same idea. And you can have multiple expressions. Now, if he had just lifted text out of the Chernow biography, that would have been a violation of copyright. But it doesn't protect the idea. That's an important thing to understand.
But he is paying Chernow rights.
No, he's not.
Yes, he is.
He is? I didn't know that.
Chernow gets a chunk of the profit.
Well, then there must have been some content that he's using then, because the idea the idea is free expression, but he may have. He's perfectly free to turn around and say to.
Chernow was involved in it.
Well, if Chernow was involved in it, that's different. I mean, that's.
Well, I think he was involved. Like, come see
Yeah.
what we've done.
Right. Well, and then if you can always turn around and contract with somebody and say, I've read your book, I'd like your help on this. You see that quite often when a common form of a derivative work is somebody writes a book, particularly a nonfiction book, and they want to do a screenplay, and then you see that the author of the book has been hired as a consultant to which I would imagine is what happened with Ron Chernow. He's hired to make sure that the content is historically accurate. That is different than copyright. That is a consulting contract. Unless Lin-Manuel Miranda used actual text from the book, he did not need Ron Chernow's permission to write the play. He's perfectly free to ask him to help out, but he's not obligated to do so. So, an important thing about copyright is it attaches when you put the expression into a fixed medium, whether it's print, film, whatever it happens to be. You do not have to register your copyright to have rights. Copyright comes from merely putting it into a fixed medium of expression. Now, registration is essential if you're going to sue somebody for infringement, and we'll talk a little in a minute about what infringement is. But if you have material that you want to protect, the first thing to do is to do simply a copyright notice, such as that C in a circle. But if you've spent any money on it, if it's something you want to protect, and we're going to talk about a number of ways to protect intellectual property tonight, and copyright is the least expensive. It's like a $40 filing fee, and it's very easy. A lot of my clients just go ahead and register on their own. Some will sometimes come in and say, teach me how to do it, and then they do it going forward. But it's really pretty easy to protect the copyright and register. Not expensive, something to think about. So, who owns the copyright? The short answer is it's the author of the work, but the big question is, who is the author? So I wrote that content. I'm the author. I have the copyright. However, if I had my associate write that as my employee, I would still own the copyright. But if it's a third party, an independent contractor, such as a web developer, then it is the third-party independent contractor who owns the content unless there's a written assignment. And this can be very important if you're, as a web developer, you're in a dispute with the client, they're not paying, you own the content. I've done that with one of my clients was a web developer, and because I had drafted their agreement, it said the copyright did not get transferred to their client until paid in full. Client refused to pay. We sent them a notice. You're publishing our copyright. You're infringing on the copyright. And you will often what happens, and this leads to some confusion where the author of a book will assign the copyright to the publisher, and then people will say, hey, can I use something from your book? And the author says yes. The author doesn't own it anymore because they've assigned it to a book publisher. So that an assignee can own the copyright to a book. Who does not own the copyright? Well, Carlton. There's a big controversy right now. You remember Carlton? Probably you're all too young to remember Carlton, but he was back in the old days when Will Smith was known as the Fresh Prince of Bel-Air, and Carlton was on the show, and he had this little dance. And there's this big controversy on Fortnite because there are all these memes that are being created out of celebrity dances, and the celebrities are saying, hey, wait a minute, like Carlton, that was my dance. I invented it. I have the copyright. And they're not getting very far with these claims. And there's two reasons. One is ownership. Carlton, Alfonso actually, doesn't own the copyright. The people who made the TV show own the copyright. He and every other actor on the shows signed their rights over to the NBC or whatever the network was that put the show on the air. So he doesn't have any rights to assert to begin with. But secondly, to to be not everything that you put into a fixed medium of expression can be protected by copyright. There's got to be a certain level of originality, and which must have been a blow to Carlton's ego. The court said these dance moves just don't rise to the level of originality. So that must have been kind of a bummer for him. The threshold for originality is pretty low. There was a case some years ago. There's a religious sect out in the Midwest, and they believe that their sacred text was dictated by celestial beings and communicated from the celestial beings to those people on earth. And a woman decided she was going to write a book about this and included the entire text. And the religious group sued her, and she asserted a couple of defenses. The first one being that these people didn't have the copyright because it was really the celestial beings who created. The court didn't find that persuasive. A licensee. This is very important when you think about, and when we start to talk about infringement. You can grant, remember I described copyright as a bundle of rights. So you can grant certain elements of that bundle. So I could say, for example, you might get for a photograph, you get a license to use a photograph on your website, and then you want to use it on somebody else's website. That's a breach of the license. That's an infringement. This happened with the Cape Cod Chamber. This is something you all should be paying attention to. The Chamber allows members to post photographs. One of our members, and I'm not disclosing anything here because the Chamber's disclosed it, but one of our members posted a photograph that was copyrighted by somebody else. And we got a nasty letter saying you are infringing on the copyright. And it's because they exceeded the license. They had a license to post it on their website. They didn't have a license to post it on our website. So whenever you are looking at content that is provided by somebody else, you need to get from them a representation and, if at all possible, an indemnification that if you get sued because their content somehow infringes, that they're going to make you whole. First, you want a representation that their content does not infringe. Then you want, if I say to any of you, create a website for me and here's some content I want, and you put it up on you create the website for me, you are considered a publisher. And you could be sued for copyright infringement if the content that I've given you violates somebody's copyright. So that's problem number one. Problem number two, and you're going to find this difficult to believe, but there are some nasty lawyers out there. And those nasty lawyers will send you a letter and say, you are infringing on my client's copyright, and if you pay me a relatively modest sum, because you keep it low, to go away, I will go away, and that will be the end of this. And in some cases, they don't represent that party at all. It's a pure shakedown. And what they do is they make the price of going away so low that you won't actually go see a lawyer. It's cheaper to just pay them to go away. And I had a client that didn't relate to websites, but he was accused of downloading a movie by this law firm from Virginia that sent him a letter, and he did come to talk to me about it, and I did investigate the law firm, and I found out that they had been reported over 11,000 of these letters. Never sued anyone. So we just said, you want to sue us? Come on up to Massachusetts. We'll be happy to say hello. Never heard from them again. So a purchaser of art, when you buy art, you don't get the copyright. You just get the copy. So I have in my office a cartoon from the New Yorker. It's a picture of Anubis. sitting in a business suit at a desk speaking on the phone, and he's saying, well, I know I'm a jackal-headed lord of the underworld, Janet, but I'm still your lawyer. And I like that cartoon. Now, if I scan that cartoon and put it into this presentation, I would be infringing on the copyright. Naruto over here does not have copyright. Do you know who Naruto is?
Picture himself, right?
Right. There was this wildlife photographer who was in Indonesia, and he put his camera down on the ground. And a bunch of monkeys came over and started playing with the camera, and they started taking monkey selfies. And they're rather charming, and they went viral. And so the photographer then went and applied for copyright. The Copyright Office said, sorry, you're not the author. So then the question came up, well, he's not the author. Who is? So the people for the ethical treatment of animals then sued, and they named the monkey Naruto. I don't know where the name came from. They sued on his behalf to assert that he had the copyright, but the court said copyright does not, animals cannot register a copyright. So nobody has the copyright to Naruto's picture. He's not getting any royalties from this. And then, of course, if you're an infringer, you don't have any copyright. Sure.
But when the photographer put that online, wouldn't he have then been the publisher of the photo?
It's not the publisher, it's the author. The author has copyright, not the publisher.
So if the author has...
So it's the person who creates the work. Publishing is a separate, that's a right under copyright, but it's the author of the work. So the question is, who took the picture, not who eventually put it on the internet. Because you can publish, I can take a picture and put it on my website, and then you could take a picture from my website and put it on the internet. You're not the author, you're publishing it, and you would, in that case, probably be infringing. So, no, by putting it on and you know, this starts to raise some issues, as you know, as I was saying, the law changes, technology changes. As we get more and more in the world where AI is creating images, who's going to have that copyright? I don't know. Maybe, but because Naruto didn't have copyright, I didn't have to contact him in Indonesia and obtain his permission for the use of this photograph. So what is infringement? The first thing is, it's the use of a work without permission. Use of the work, as I said, in excess of the license. An employer can be liable for employees' infringement. So if you have employees, and you should have in your employment agreement a prohibition on using copyrighted material. Because it's easy to do. People don't understand copyright. They think surprisingly, people think if it's on the internet, it's available for use, and it's not the case. So a few years ago, there was a woman who posted an article about, she had this apple pie recipe that she liked. She posted an article about the apple pie recipe. She put the little copyright notice on there claiming copyright. And the editor of an online food magazine basically lifted the article whole and published it in the magazine. The original author wrote and said, hey, wait a minute, this is my content. I created it, I'm the author, I have the copyright. To add insult to injury, the editor wrote back, well, it was on the internet, I'm free to use it, and oh, by the way, I edited and made it better, so you should be paying me. The author posted this response, and it went viral, and what wound up happening is it caused people to start looking into this magazine, and they found multiple cases where they had just stolen content from people, and the magazine lost all of its advertisers and went out of business. Fair use, parody, and memes. So there's a concept called fair use. And fair use allows you to use a portion of a copyrighted work without infringing. So The classic is I'm writing a review of a movie or a play, and I use a couple of lines of dialogue. That's fair use. The problem with a fair use defense is there's no bright line. So nobody can say that 10% is fair use, 20% is fair use. So it's not something you want to rely on, except if you're, if you're using it in one of the classic fair use ways. However, one thing that's very controversial these days is, what do you do about memes? We see them all the time on Facebook. A lot of people think they're fair use. The good people at Getty, do you know about Getty? Getty is the company that has all these images, and they're real hard asses about suing if you misuse one of their images. Lots of times, if you infringe on copyright, somebody will just write you a letter and say cease and desist, and if you cease and desist, they'll be satisfied. Not Getty. Getty always wants money. And Getty has sued somebody over the use of, gotten a judgment over the use of an image. It's an area that really is unclear. There's a, if it were more clear, were fair use. There's an image, guys, what beer is it? I'm not always thirsty, but the most interesting man in the world. Yeah, and there's an image of him saying, I don't always post pictures and memes, but when I do, it's fair use. And I thought about using it, but then I said, I really don't know if that's fair use or not. Probably not a good idea for me to infringe on copyright while I'm talking about copyright law. Yeah, Pat?
It's just a thought. A lot of the designers, we all have a portfolio on our website. Now, sometimes they have pictures on websites are stock images for use on that site. Is that a copyright infringement showing that on a web designer site as part of their portfolio?
So it's something you created for another person?
Right.
What I would do is I would have in my agreement that I can, and I've seen this in agreements, that I can use these, what I create as part of my portfolio.
Yeah, and you have it.
And then, yeah.
But then you're taking a picture of.
But you can do it if you've got permission. The question is, do you have permission?
So it should be in your agreement.
Right. And that gets to the default. The default is always get permission. Gene.
So just to follow up on that, I think what she's saying, if the homepage that you're taking a screenshot to show that you developed this website has a licensed image from Getty on it, look at the screenshot and show it as this is a website I created. So now it's a picture of their homepage with a licensed image.
You might hear from Getty on that one.
Maybe just give it a little bit of a blur right on that.
Yeah, I would think I think that's a good solution because,
Is that your question? Yeah.
Even, families that have pictures of themselves on their own
So-
pictures are, like Andy Newman, he's a graphic artist, he does wonderful work and everything, but, if a site was done for him or something like that, and his pictures were put up as part of the portfolio of work that the designer used.
it comes down to, Pat, it's going to come down to,
Into a forest here.
well, no, it's very simple. These are the kinds of things that you address with agreements. Can I use this? Yes or no? I mean, it comes down to a very simple question. Do you have permission?
But what if the permission is only given?
Then you're infringing.
No, only given to the person who owns the website.
Then you're infringing. That's what I'm telling you. That's the person who,
But you can't go to the client, or you have to go to get it and get permission.
yes, you have to buy your own license, yeah. Because the client doesn't have a license to post that picture on your website.
Right.
So what do you do about this? There is a way to protect yourself to some degree, and the Digital Millennium Copyright Act, DMCA to aficionados, has a lot of different provisions in them. One of them is a provision that provides a safe harbor for online publishers. If you put up a DMCA notice on your website, which essentially says, if you believe any of the content, and this is if you're reposting somebody else's material, you're hosting third-party material on your website, like you're a membership organization and your members are posting pictures, or you're other people are posting their art, or whatever it happens to be. You can put a DMCA notice, which essentially says, if you think we're infringing, contact us and we will take down the material. And if you do and follow, if you have that notice and follow the process, then you will not be sued for copyright infringement. Now, it's a little more complicated than that, because what winds up happening is then you have people who are in bad faith sending out takedown notices, and you as the host have some obligation to at least look into the situation and have a good faith belief that it may be infringing. But that's a possibility of a way to protect yourself. So if you look at the Chamber of Commerce website, they have a DMCA notice on there now, because that was exactly the situation they had to deal with. Sure.
On those lines, would that notice have to be on the page with the image, or could that be like in your terms and conditions?
Usually it's I would put it in the terms and conditions. You could put a link on it, a link to it on the homepage if you wanted to, DMCA, but most often you'll see it in terms and conditions.
So occasionally I'll use a stock photo on a blog post, right? I buy it for that use. If I post a link to the blog post on, say, LinkedIn or something else, the photo will appear because that's how.
Yeah, I don't think that's a problem.
Awesome.
Yeah, no, the links to other websites have not typically been a problem.
Gene, would you put that on every website or just for user-generated content?
Well, it's a somewhat complicated process, so I would evaluate how much you need it, because you also have to then have somebody register with the Copyright Office as the person to handle these types of complaints. So there's a little bit of complexity to the process. So what it's really designed for is the situation like what I described with the Chamber of Commerce. We allow our members to post photographs. We say, we don't want you to post any infringing photographs, but to be on the safe side, we're going to have this extra level of protection. But it involves some doing, and with anything you put on your website, you don't want to say, we do this, and then not do it. Because then you're definitely exposing yourself to getting sued. So you really need to think about, does the client have a need for this type of protection? If it's a website where I'm just posting my own content and then I wouldn't bother. And then there's a spectrum of how much activity is going on, and you have to just kind of figure out where the client is, and will the client then follow through on the process? Because if you say, this is what I'm going to do, and then don't do it, then you're in trouble. So just some practical realities. I think we probably covered most of these. Content's available on the internet, not necessarily available to use. If your client provides you with content, get a representation and indemnification. Use a copyright notice. Consider DMCA protection. That should be DMCA. Consider proofreading. And beware of trolls. So now we're going to shift to trademarks, which is another area of problems for websites. So what is a trademark? A trademark is a mark, or it is something that identifies the source of goods if it's a trademark, the source of services if it's a service mark, and we're going to refer to those sort of generically as trademarks as we go forward. And then there's a third type of mark which doesn't come up all that often, called a certification mark. And a trademark and service mark, basically, the trademark is mine. I'm the source of the goods or services. So we use a slogan. It can be a pattern. It can be like the Burberry plaid. Some years ago, had a client posted on their website, we have clothing with a real Burberry look. They got a letter from a real Burberry lawyer inviting them to a real federal district courthouse in Manhattan. A certification mark is different. The certification mark doesn't identify the goods or services. It's a mark that you license out. You're the owner of the mark, and you set up a series of standards. And if a third party complies with those standards, they can use the mark. Probably the most famous certification mark in the world is the UL mark. Go to buy any piece of electronics, and you're going to see UL at the bottom. That means it complies with standards developed by Underwriters Laboratories, which is a large testing and certification organization. We're going to not really bother with that. We're going to talk mostly about trademarks and service marks, which I'm just going to refer to as trademarks. Trademark, you get trademark rights from first use in commerce. Again, like with copyright, you don't have to register. But like with copyright, there are benefits to register. And the process, unlike copyright, there's state and federal registration. So if you have a mark and you're only engaged, if your client has a mark and they're only doing business in the Commonwealth of Massachusetts, they're not in interstate commerce, they can't get a federal registration, but they could get a state registration. And when you think about trademarks, there's a spectrum of strength of marks. And the strongest mark are arbitrary or fanciful marks, and there's a logic to it. The whole point of trademark is to identify a source of goods or services. Think of it as a brand. So an arbitrary or fanciful mark, like Amazon, before Jeff Bezos came along and took over the world, nobody associated the word Amazon with the sale of goods or services over the internet. That association has been entirely created by his marketing efforts. And because it was created by his efforts, he gets rewarded with a stronger mark that's easier to enforce. The next level is what's called a suggestive mark. It's not necessarily, it's got some relationship to the product or service, but you got to think about it a little bit. Like Roche Motel, roaches check in, they don't check out, so there's some association there. Marks that are descriptive are hard to register, and this is a particular issue on Cape Cod. So on you get a lot of companies that are Cape Cod this, Cape Cod that. So if I wanted to register a mark, let's say I was, instead of being the law office of Eugene R. Curry, I was marketing myself as Cape Cod lawyer. So, and let's say that I went to try and register that mark with the Patent and Trademark Office. Well, it might be that the examining attorney is going to look at that and say, Mr. Curry, that doesn't identify you as the source of legal services. It identifies the geographic area where you're providing services, hence it's not acting like a trademark, hence you cannot register it. And one of the things I tell my clients is your experience at the Patent and Trademark Office is very, very much going to be a function of the examining attorney who gets assigned to your case. I've had examining attorneys call me and say, hey Gene, if your client makes this minor modification to their mark, we can get it registered. And I've had examining attorneys who wouldn't return phone calls. But one place you can see the difference in examining attorneys is you will see marks with the words Cape Cod that got registered without a problem, and marks that had to go through several other hoops. You can get past this if you've been using the mark over an extended period of time. But you can really see that the exact same mark gets treated differently by a different examining attorney. Generic marks, if it's just the name of the product, are not registered because they're not used as a mark. It's just the name of the product, so it's not going to tell you who's the source of goods or services.
Does that apply to like an app also?
What's that?
Does that apply to like an app where you can't trademark the name of
Well, trademark, you don't trademark the names of apps or names of books. That you can't trademark an individual book, but if you have a number of books, so that you start to develop a brand around that book or those characters, you can trademark that, but that's the same with an app. If you developed a suite of apps, then you would get to the point where it would be considered to be identifying the source of the goods or service rather than just the program itself. And infringement is the unauthorized use of a mark. And so when your client is telling you, I want to use this, and it's something that's trademarked, and sometimes it's something you would even think wouldn't be a problem. So I had a client that was a reseller of industrial brakes, and they put photographs and material about the industrial brakes that they resell. They got a letter from the company saying, you did this without our permission. We consider this to be an infringement of our copyright and an infringement of our trademark. And so, we got everybody to calm down. But that illustrates a point here, and it's important for both copyright and trademark. You see this all the time. Fortune 100 company sues some little mom and pop over trademark infringement. And everybody's scratching their head and they're saying, why are they doing this? Mom and pop really can't be cutting in on Fortune 100 companies' business. And the reason is because if you do not police your mark, you lose your trademark rights. So if they let mom and pop get away with it, and next year their biggest competitor starts infringing, and they go to sue their biggest competitor, the competitors are going to turn around and say, well, you let mom and pop get away with it, so you don't have trademark rights anymore, or you don't have copyright anymore. And I want to circle back to copyright for a moment. Trademark, so somebody infringes on your trademark. You sue them for damages. And the damages are things like lost sales, to the degree, it's hard to calculate, you need an economist to do it, but you show how that infringement has hurt you. Copyright is a different story entirely. Copyright has a concept known as statutory damages, which means for each violation, without any proof of injury, you can be assessed damages of up to $150,000 per violation. So 4 or 5 years ago, there was a college student, watch out, college students, and he used file sharing software to share 33 songs. 33. The record company, the record industry, those kindly folks that they are, sued him, and statutory damages were awarded in the amount of $615,000. There's no way on God's green earth that he injured the record company to this tune of $615,000. Now, there are people in the legal community who feel that part of the reason he got such a whack on the head was he had a lawyer who was more than a little bit of a bozo, but bozo's a legal term, by the way. So, again, the issue is, will the use of the mark lead to confusion about the source of goods or services? And this comes up when your clients, comes up in a lot of places, but typically one of the places it'll come up is you're starting a business, or your client's starting a business. And they say, I'm trying to come up with a name. And the problem often is, in the particular industry, whatever it is that they're doing, the easy names are already taken. And it's hard to think of a name that's not going to infringe on somebody else's. Sometimes they don't even think about it. So I had a client, they developed some technology. They didn't talk to me about the name. They went out to a trade show, got a lot of interest in the product. And the way I wound up getting involved is they came to me and said, hey, Gene, we're ready to sell these things. We need a contract for the sale. And I said, oh, great, what's the name? And I said, that sounds like the kind of name I would give this product. And I went and Googled it, and lo and behold, exact same competing product, exact same name. So we had to change the name. But you want to figure this out when you're starting out. You want to figure it out. You don't want to be 2 years in, spend $20,000 on branding, and then get a letter, oh, by the way, you've registered, you're violating our trademark. And there's a number of ways to get at it. The sort of quick and dirty way is Google it. Go to the USPTO website, click on the trademark search button, put the name you want to use in, see if anybody is using it. Now, if somebody is using it, that doesn't necessarily mean you can't, because the test for likelihood of confusion, there's basically 13 elements the court use. The two most important are the similarity of the mark and the similarity of the goods or services. So there's Sun Microsystems, they make the Sun Spark workstations. And there's Sun dish detergent. Same mark, very different products. It's not likely that I think this company that produces dish detergent produces high-end computer workstations. So you can, and one of the problems here is, as you go through the checklist, it's really more of an art than a science. Reasonable minds can differ about whether there's likelihood of confusion or not. And so there are people who you can pay to help you come up with a unique name, or sometimes you have a unique circumstance. There used to be a company on Cape Cod called Taqua Systems. And I don't know if back in the day, they raised $120 million in venture money and then kind of went away. But a friend of mine was the CEO of Taqua Systems, but when he joined the company, it had this sort of generic technology name that he thought was pretty boring. And it turned out that they were having some people do some work on their networking, and they had been up in the Canadian Arctic doing work with the Inuit people, and one of the Inuits had come back to Cape Cod and stayed with the company. So my friend Dave said, hey, let's go out for a cup of coffee. And they started talking about different ideas that they might use for a name. And it turns out, well, whales are mammals, right? So they got to come up periodically for air to breathe. Sometimes in the Arctic, sadly, with climate change, less frequently, there's ice covering the water. The whales have to punch through the ice. The Inuit word for that is Taqua, which means great force rising. And my friend said, I like that. First of all, nobody's using it for software. Secondly, isn't great force rising kind of a cool association to have with my company? So that's, you got to think a little creatively and not necessarily go for the thing that's going to be most like your goods or service. So again, practical realities. Think carefully before using the mark. Use the trademark symbol. If you're registered, you can use the circle with the R, but you don't need to be registered to use that little TM thing. And that puts the world on notice that you consider this to be your trademark. You need to police your mark. And also, if you do register your mark, you have to maintain the registration, which means every few years you've got to file paperwork with the Patent and Trademark Office. Otherwise, they'll cancel your mark, and you got to start all over again.
So if you use the TM, you don't have to register?
That's correct.
Is there any reason why somebody would want to take the TM off of the logo?
Sometimes people are sensitive. They want the logo to just be the logo without the. But you can. Yeah, no, I've had clients be resistant to that, and there's, it's a related issue whether you're online or not online. We'll get to this. I'll just do it now, but but I've had clients that say, well, do you want to let the world know that this is a registered mark? And then we get into a big discussion about when they've registered the mark, where we're going to put that circle with the R on the website, how often we're going to use it in contracts, things like that. Same thing with Inc. or corporation or LLC. If you have a limited liability entity, you've incorporated, you've set up an LLC or what have you, if you don't put the world on notice that they're dealing with a limited liability entity, and the whole point there is I want to separate my business liabilities from my personal assets. If you don't put the world on notice, then they can act as if you're not. So I can't tell you the number of times I get a new client, and one of the first things I do is I look at their website, and it just says, the name of the company without Inc., LLC, and then one of the first things I tell them to do, you got to correct that, because
Where would it have to be on a site? Could that be something in the privacy policy?
you'd want it.
That have to be on like the front page.
I would put it on the front page, and where I would put it is I would put a copyright notice on the website, and it's copyright ABC Company Inc. And then I would put in the terms and conditions, this website is owned by ABC Company Inc. And I put in the privacy policy. We at ABC Company Inc. value your so it doesn't have to be everywhere, but it does have to be where people are going to see it. And that also, if it's your company, you also want it on your business cards, you want it on your checks, you want it on your stationery. If you've got a banner, you want it on your banner, you want it every place people are likely to see it. A few years ago, I had a marine construction company that was my client. And they put up they're building a corporate headquarters, put up a sign, future home of X. They didn't say X Inc. And they got sued. They were in a dispute with the contractor, and they got an attachment on the owner's house. And it was a week before they were scheduled to close on the sale of the house. So you can imagine how happy his wife was with this turn of events. And we were able to get it removed. Went into court, but they paid me to be in court for a day instead of paying a sign painter to write 3 letters in a period on the sign. So if you're setting up websites for your clients and they're in a limited liability entity, you should be making sure that the website tells the world that they're dealing with a limited liability entity.
Is one more forceful than the other? And say you have a trademark, it's not registered. If someone litigates against you, do you have to get a registered mark before your mark?
The question is, you're kind of mixing apples and oranges there. So first, you only use this with a registered mark. If you use it with an unregistered mark and later go to register it, the USPTO may turn you down on that basis. Then the question, if somebody sues you and claims you're infringing, there's going to be 2 separate issues. It's not really going to relate to whether you're using the TM or not. It's going to relate to who had first use in commerce, and is there a likelihood of confusion.
So what's the advantage of registering versus just slapping a trademark on everything?
Well, the advantage of registering is, first of all, you can't sue for infringement until you've registered the mark. And then there are other advantages as well. Once you've registered the mark federally, there is a presumption that the mark is valid. If you are without a registration, you can be challenged on the validity of your mark. And after a period of time, it becomes very, very difficult to challenge the validity of the mark. Further, it puts the world on notice that you have this claim of trademark from whenever it is you go back. Because one of the things, so as I said before, I encourage people, if they're thinking about coming up with a business name or a trade name or what have you, do one of the things you do is you look at the USPTO website, and if you've registered the mark, you will be there. You will be found. And somebody will say, oh, he's got the mark. I can't do this. So it's got a preventative effect on people coming in and trying to use the same mark.
It's kind of like, instead of standing at your house with a megaphone, you drop papers to everybody around the world that you have that mark.
Yeah, it's probably more effective than standing on your front porch with a megaphone. I don't know, you may have a loud megaphone. Yeah.
So I did register a trademark. And I used the TM on it when I wrote about it before I got the mark.
Mhm.
Now do I have to do a universal search and replace all my TMs with Rs?
Well, you don't have to, but it wouldn't be a bad idea. It's not a legal requirement, but it's more valuable to you to use the registration symbol than the TM symbol. And again, as I said, you have to police the mark. Another thing to consider when you're dealing with photographs and other issues is that in Massachusetts, there's rights of privacy and publicity. And that basically means I can restrict your ability to use my image for commercial purposes. So your client is planning to have a bunch of people come in and be videoed and say, I really love this product. You want to get a release from all of those people. And again, as I was saying, how the internet poses challenges. When you draft the release, you want to say, one, not only are you telling me that I can use your image, but you're telling me that I can manipulate it and edit it and do all sorts of other things, modify it without further permission from you. And I can use it in every medium we know now and any medium that might come up in the future. So there's a very famous movie that almost nobody has seen. It is a documentary about Robert F. Kennedy that was put together after he was assassinated, shown that year at the Democratic National Convention, but it was put together from an amalgam of different sources, and nobody knows who has all the rights to the images. And it's limited to that one showing, so you can't take it and take it further. This came up in the early days of the internet, where the New York Times wanted to post all its content digitally, and all of the people who had written for the New York Times started saying, hey, wait a minute, I only signed a contract saying you could take my content and put it in the newspaper. I never said anything about posting it on the internet. So if you're going to use somebody's image commercially, you want to make sure that you're getting that permission. Then there's privacy laws, and you have to be careful about using somebody else's image, particularly if it's a celebrity. So there's mostly in the California in the West, there's Carl Jr. hamburger chain, and they announced that they were going to roll out a new burger called the Spielburger, and they said that we believe that Steven Spielberger loves our burgers, and I'm sure he'll be happy with this. Steven wasn't. He said, no Spielburgers for you. But in a sort of backhanded way, he did say, but I do like your burgers, I just don't want to let you use my name commercially. So then they said, Steven Spielberg likes our burgers. So if you're thinking about, people have this tendency, they want to use an image of Humphrey Bogart in his Casablanca trench coat and hat and as part of a bar. Well, you might get sued by Warner Brothers over that. You don't have the right to just take somebody's image and use it commercially. And so if your client wants to do that, you need to caution them that this may be a bad idea.
Is there a limitation,
Actually, it varies very much from state to state. And in some states, the right doesn't attach after death. In some states, it does. So if your client wants to do this, it's something that needs to be researched so you know what we're dealing with here.
To make sure I understand correctly, the first point, I'm working with a photographer doing a photo shoot next week at a restaurant. And so if she took a photo of people at the restaurant eating, we should get their name and their consent.
Yeah, if they're identifiable, yeah. I mean, again, my default is always get permission, rather than be sued for not.
He just needs a release, right?
Yeah, that's permission.
Sign it.
Yeah, that's what I'm talking about. Yes. Yeah, that's exactly what I'm talking about. The document that I've been talking about is called a release.
If someone voluntarily shares with you over social media a picture of themselves and their child or whatever, or in a museum, is that giving you permission by giving it to you? They took it, they send it to you. Look at my kid. Yay.
I'd still get permission.
Tend to like it and say,
My default says give it permission. Because
explicit permission.
Yeah, because that has happened. Where it's come up is companies have said, we're going to have a contest on, Instagram images or whatever,
Right.
and we want the silliest picture of you using my product, whatever it happens to be. And then people have turned around and said, well, I didn't give you permission to use it for these purposes. So now people write very specific rules. By entering the contest, you're giving me permission. So you could put on the website, which we're going to talk about terms of use. I often put in the terms of use for the website. If people are posting content, I put in the terms of use. When you post to my website, you are giving us permission to use your content, whatever, or pictures or whatever. And of course, we all know that nobody reads the terms of use. There was actually a study done 2-3 years ago. 500 people were approached and they were told, we have this app, we'd like to let you use it. Here are the terms of use. And please indicate that you agree to the terms of use and we'll let you use the app. Of the 500 people, only one person declined, notwithstanding the fact that the terms of use specified, we are going to take all your data and give it to the NSA, and you're going to give us as compensation for allowing you to use the app, your firstborn child. Obviously, only one person read it. I suppose we could also assume there were some people who read it and just didn't have a problem with giving up their firstborn child or their data to the NSA. I think that's a little unlikely. There's a related concept, and that it's called moral rights, and it's got nothing really to do with morality, but it's a right of, and it applies to art and artistic materials, and it is a right of attribution and a right of integrity. So it can prevent, if you're an artist, you can, and even after unless you assign these rights in a contract, you can prevent somebody from changing a piece of art that you have done. So there's a sculptor who did a piece of art up in Boston, did a sculpture for a nonprofit sitting in the square in front of the office building of the nonprofit. Nonprofit moves, and they want to take the sculpture. And the artist objected. He said, oh no, I designed this sculpture to be in this location. And if you move the sculpture from this location, you are damaging my art. And the artist won. It's all about getting this stuff in writing and getting permission. If they had been my client, silly them, we would have had an agreement that said, you are assigning the moral rights to this work to me in exchange for paying me money. So, in addition to private parties, we got to think about the enforcers. And I start with the Federal Trade Commission. Part of the reason for doing that is the Federal Trade Commission was created to deal with cutting-edge legal issues. And there is no general internet enforcement agency in the federal government. But the closest thing to it is the Federal Trade Commission, and we're going to discuss a number of regulations that they've got. Now, having said that, that doesn't mean if your client violates one of these rules, a SWAT team from the FTC is going to show up to take them out. But the Federal Trade Commission is very important because every state in the union has a consumer protection statute modeled on the Federal Trade Commission Act, and violations of the Federal Trade Commission Act are violations of your state Consumer Protection Act. So you may well hear from the Mass AG, and unlike the Federal Trade Commission Act, which has no private right of action, which means as an individual, if an FTC violation happens and my rights have been violated, I can't sue the violator for a violation of the FTC Act. But I can sue for a violation of the Massachusetts Consumer Protection Act. And furthermore, if I succeed, not only do I get my damages, but I get reasonable attorney's fees, a concept that I truly love. And if the action has been intentional, up to 3 times my damages. So you need to be aware of these regulations, because if your client gets sued or you get sued, the penalties could be severe, and it's something that people tack on to lawsuits on a pretty routine basis.
So is that how, like, Volkswagen got sued for the diesel engines not meeting the emissions? That was because it was the class action lawsuit was with a state. It wasn't with
Well, it was a couple of things. It wasn't. First of all, that was an FTC case. But the thing is, you could have a class action based upon a state law. So Volkswagen misrepresented to me that the engine was cleaner than they said it was. So you could sue them under state consumer protection statutes. You could sue them under contract. And those class actions would be typically under state law. And then the state attorney general's office, they enforce the local Consumer Protection Act. State corporations divisions, we'll talk about that, state tax authorities. EU with respect to things like the GDPR, various state agencies enforcing state privacy policies, which is a real changing mess. Mess is another legal term. And then private parties, as I said. So one of the things that has happened is our friends at the Supreme Court, having recognized that the internet has changed the world, have also recognized that internet commerce has changed how taxes should be collected. So it used to be that if you were going to pay sales tax, if you're selling products in a state and you're going to pay sales tax in that state, you had to have what's called a physical nexus. It's essentially a physical presence in the state. And so Main Street businesses were complaining because Amazon isn't collecting sales tax and I've got to pay sales tax. I'm at a disadvantage because of that. And last year, the Supreme Court, in a case that was involved Wayfair versus South Dakota, recognized that that really didn't reflect economic reality anymore, and that has left the states to come up with a whole range of different ways of measuring whether or not you're doing your client by sending goods and goods principally probably, but goods or services to other states, is going to have to pay sales tax on those states. And in some states, there's a threshold. In New York, it's $100,000. But it varies from state to state. So if you have a client and they're selling stuff, they need to be paying attention to which state, where they're selling, and need to understand what the thresholds for paying sales tax in those states are. And there's software that will help you do this. Some of it is expensive. I have a situation where my client has basically spent $750,000 on an enterprise management software platform that has some problems. And one of the problems is it doesn't integrate with their program that calculates sales tax in each of the 50 states. And also you have to remember, in each of the 50 states, it's not only the thresholds are different, but the things that are taxable are different. And I was having a conversation with the lawyer for the other side as we were trying to resolve this dispute. And he said, well, you know, it does work, but it's just not always accurate. And I said, well, you know, my wife is a certified public accountant. And if I use the words sales tax and inaccurate calculation in the same sentence, her head would explode. But so it's something that your client needs to be aware of. And again, it's again something that's changing. The states are still in process of revising how they're going about charging sales taxes.
I remember one that first came down from the Supreme Court that I think it was someone in New Hampshire brought a lawsuit against that because they were a small business and they, since New Hampshire doesn't charge sales tax, they then have to calculate it
Right.
for all of these other states when it's something they don't have to already do for their business. Do you know, did anything end up happening with?
Well, I'm not familiar with the New Hampshire case. Wayfair was involved the state of South Dakota, and
Right.
so I'm not. I don't know the New Hampshire case.
Okay, yeah, but it happened right
But-
after the Wayfair.
Right, but there's a lot of. But what's happening is clients are getting letters, and sometimes the letters say, "Well, you owe us sales tax," and they're looking. Well, we don't mean. They just start spitting out the letters, and then you got to go back and figure out. Well, do we really owe something here, or don't we? Related to that is corporate registration, which is if you are doing a certain level of, have certain activities in other states, as part, even if you're incorporated in Massachusetts, and you have activities in other states, you may have to register as a foreign corporation doing business in that state. And again, it varies from state to state, and sometimes the regulations of the states are in conflict. So I've got a client right now where, as I read the Florida corporation statutes, under the corporation statute, they don't have to register. However, their accountant reads the state tax regulations and says, yeah, but we got to pay sales tax for the activities that we're doing there. However, in order to pay sales tax, they have to register as a foreign corporation. So they wind up registering even though the state law says they don't, because the sales tax law and the corporate registration law are in conflict. So just makes life that much more fun. A related issue is state jurisdiction. And what I'm talking about there is how much activity does your client have to have in a state in order to be sued in that state as compared to being sued in Massachusetts if there's a dispute about the product or service that they sell. And again, it's just not clear. The general thinking is that if you have a static or an interactive website, but a static website where people are just coming to your website and I order goods and you get them delivered, that's probably not enough. But then the question becomes, what is enough contact? And so I had a client, and it doesn't have to be just sales. So I had a client here in Massachusetts. They did a review of some software, said it was really terrible. The company, which was based in Louisiana, said, well, we're going to sue you in Louisiana for defamation and slander. And we wrote back saying, well, you don't have enough contacts. That's not going to work. First, my client did. He sent an email, and then the lawyer for the other side, who's also a bozo, said, aha, you sent me an email in Louisiana, now you have enough contacts. Well, the good news is that when they filed a lawsuit, we got it dismissed. The bad news is when they filed a lawsuit, we got it dismissed because we had to hire a law firm in Louisiana to appear in court to argue that there wasn't enough contacts. So we had to spend a significant amount of money to make this lawsuit go away. But it's, as your clients start to be doing business in multiple jurisdictions, it adds complexity to their potential legal liability.
Was the email server located in Louisiana? Or would that then
No, 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 that's,
an email contact based on where the access is?
no, it's not where the server is located, it's where the party is located. So, first of all, a single email correspondence responding to a demand letter from a lawyer is not going to get you jurisdiction. But on the other hand, if you did an email blast, whatever I'm selling is on sale, and I sent email to all 50 states and then sold products in several of those states, and the products failed, and I got sued in each of those states instead of getting sued in Massachusetts, that might be enough. It's going to vary. Again, it's a question of state law, and each state varies the threshold for what constitutes enough contact to create jurisdiction.
What about the physical location of your server with your website itself?
That's an interesting question. That might be.
In Germany, they require all of the websites for German businesses to be within the country.
Well, and you'll see that in some contracts too, where it'll say, we want all your websites to be in all your service to be in the United States, or all your service to be in Massachusetts. Potentially that could be an issue. I'm thinking, maybe for GDPR purposes, if your web server is in the EU, I think that's probably going to create.
Would it affect your presence, like your physical presence in a way?
It could, but I think the more significant factor is, I think that would probably be enough to get jurisdiction. And but again, it's going to depend. It's going to be a question of state law, and each state is a little bit different.
And where that is has to actually benefit the person.
Yeah. So those are the stated forces. Now, our old friend, website accessibility. I'm not going to spend a lot of time on this because I know that Dylan did a program here a couple of months ago. But what you should know is that I'm aware of at least 5 local businesses that have been sued because their websites are claimed not to be compliant. It is the same lawyer in each case. It is the same plaintiff in each case. And these lawyers who pursue these suits are notorious for having offices and websites that are not ADA compliant. And what the problem here is that there's really not a clear standard of what is compliance. In September, the Department of Justice wrote that business owners have flexibility in determining how to comply, and that failure to comply with the web content accessibility guidelines doesn't necessarily mean non-compliance, but it's basically kind of like the troll shakedown. The person with a disability doesn't necessarily get any damages, but there's a payment of legal fees. And so they're going to want you to pay legal fees to make this go away. So now we should be encouraging our clients to have their websites be accessible for a lot of reasons. One, it's the law. But also, according to the US Census, 1 in 5 individuals identifies themselves as having some form of disability. So that's 20% of your client's potential market. So it's something to give serious thought to. And there's a lack of awareness that this is a problem. And when I've talked to people about this, people say, what are you talking about? So I'm on the board of directors of the Cape Cod Chamber of Commerce. I'm also, as is Gene and Amy, involved with the Cape Cod Technology Council. And the Tech Council and the Chamber have put together a website on resources for what is compliance, who might help you get compliant, what to do if you get sued. If your client gets sued, first thing to do is, I know what you're thinking. You think I'm going to tell you to call me. Well, I'm not. No, first thing to do, in all seriousness, is have them contact their insurer. I am told, but I do not know for a fact, that in at least one of the local cases, the defendant had insurance that would cover. And so you want to contact the insurer ASAP for two reasons. The first is your insurance policy is going to say you have to promptly notify them of a claim. So if you fail to promptly notify them, they may deny coverage. And wouldn't that stink? You've paid money for the coverage and then they don't cover. But the other thing is, if the insurance company is going to cover, then they're going to pay for the defense and they're going to want to select the lawyer. So the first step is see if you've got coverage. Second thing I would always recommend is get compliant as quickly as possible.
Is that coverage you can specifically request?
Yeah, there's employer, I forget the name off. I've got it it'll come up later. I'll tell you exactly what it is. So that's, I'm not going to cover a great deal of what the technical issues are. I think probably most of you are familiar with that.
I'd like to just say something with like the website accessibility too. If you're not, like, if you don't take that, into consideration when you're building them, I mean, it's kind of like, saying you don't care about all the people, and a lot of it has to do with, blindness or in websites, blindness or, difficulty seeing. So if you don't consider those.
That's an excellent point, because the other thing about this is, okay, somebody gets sued and they feel like, well, this is a shakedown, I'm not going to put up with this. Well, it's not exactly a public relations home run to announce, I'm going to fight this disability lawsuit to the bitter end. Not good, Maverick. It just, so you are absolutely right. And it's going to be easier if you can, and if you get challenged and you say, we've been working on this all along, even before we heard from you guys, you're in a better position than if you've not done anything. I mean, to my mind, there's sort of three levels of potential defendants here. One is people who know they have an obligation and simply don't care. Mid-level is people who have no idea they have this obligation and therefore are not complying with it. And the third is people who are aware they have this obligation and they're trying to comply but may not have succeeded. And to my mind, each of those people is in a different posture if they do get sued and are trying to defend their case. But as I say, I'm fighting against as much as whatever you think about the lawyers who are bringing these cases, the fact of the matter is, if you're not compliant with the ADA, you're not compliant with the law, and that's not something you want to make announce to the world. So this is just some information from the guidelines, but we're going to pass over this and move on to some other issues. So, the FTC requires that if you are promoting, whether you're an influencer or whatever you want to call it, promoting a product or good or service, and you are getting any compensation for doing that, you've got to disclose that, because it would affect how consumers perceive it. So the owners of this gambling website put up, bro, I've won like $8,000 worth of CSGO skins today on CSGO Lotto. I can't even believe it. And the FTC responded, well, bro, while we're on the subject of things we cannot even believe, did either of you clearly consider disclosing like you own the company? And along with having a sense of humor, and I started my career at the FTC, and I have a vivid recollection of, we were accused by one of the industry groups of that we were regulating of being a bunch of humorous zealots, and we responded, we do so have a sense of humor. But along with this somewhat humorous response, they also filed a 5-count complaint against this company, and they wound up paying a significant amount of money. So if you, and these endorsement guidelines have really become prominent with the whole Instagram influencer and other types of endorsements. But it goes back to it goes back to sort of the heart of Federal Trade Commission consumer protection law, which is unfair, deceptive acts or practices. And it would be considered deceptive if I'm saying, I really like this product, and I'm not telling you that I'm getting paid to say it. And there's some flexibility here. I mean, if you look, when Alex Trebek from Jeopardy is on TV talking about life insurance, probably everybody knows he's getting paid to do it. Nobody thinks that it's, so that, and the FTC is okay with that. But if you are doing something that implies that you've used the product, even if you're not getting paid, it's just, but you're implying that you've used the product when you have not, and then that's deceptive. And people had a lot of fun with this at one point, because in the 60s, the FTC went after a bunch of celebrities for not appearing to have used products that they endorsed when they in fact didn't. And if you go on YouTube, you can see this video where it's a pair of legs and pantyhose, and up the pair of legs, it eventually gets to the body and face, and it's Joe Namath, who's the football quarterback for the Jets, because he had at one point endorsed a brand of pantyhose. And whenever I do these presentations, I have a friend, we have an over-under on how many people are going to be old enough in the audience to remember Joe Namath. So there are some also, it's not only that you have to disclose the endorsement, but the disclosure's got to be prominent. And that raises problems, because if we're talking about Twitter, we got 140 characters. So the FTC looks to things like hashtag ad, but not hashtag ad at the end, at the beginning, or not in a link. It's got to be somewhere where people are going to see it, so that when they're seeing the endorsement, they're realizing that they're looking at an ad. Another issue that you may encounter for your clients is the Children's Online Policy Act. If your client intends to collect information from children under 13 or knows that they're collecting information from children 13 or under, there are certain things they have to do, including getting permission from parents, giving parents permission to correct or delete information that's posted. So if you've got, you're putting together a website for a client, and it's the Children's Museum. And if you're having kids post content, then you've got to be in compliance with COPA, which is how the acronym for the act. Consumer Review Fairness Act. I've had clients ask me, in the terms of, can I put a restriction on the ability of somebody to write a negative review about my product? The answer is you cannot. And in fact, there's a Massachusetts corporation that got sued. I did this presentation for the Cape Cod Technology Council on May 3rd, and 2 weeks after that presentation, the FTC sued a Massachusetts company on this very issue. So you can't put it in a form contract. You have a very limited ability to tell people they can't say negative things about your product or service. You have the right to, if you think this is a good idea, which it almost never is, to sue them if they say something false about your product. But, in my opinion, the way to deal with somebody who's unhappy with your product is either try and make them happy or ignore them. Attacking them, I mean, we've all seen this. Somebody gets a bad Yelp post, and then the owner of the restaurant sends this blistering response, and they look like the biggest clown in the world, and they've done themselves no favors. So, this is one of those things where, you get in a fight with a skunk, you're going to wind up stinking. That's another legal doctrine. There's the Restore Online Shoppers Confidence Act. Boy, that rolls off the tongue, doesn't it? If your client is selling, free trials must be free. You can't tell somebody you're giving them a free trial and have undisclosed conditions. And particularly, oh, give us your credit card, and if you don't tell us, we're going to charge you forever and ever. So again, these are all things you deal with disclosures, but it can be the basis for federal or state liability, which you really don't want to have. So how do you deal with some of these things? So one is you look at privacy policies. So the advantage is it builds trust with your people. More or less expect privacy policies these days. In some jurisdictions, it's required. It will be required under the California Privacy Act that's going into effect. And by the way, there's now a Massachusetts data. Massachusetts already has among the most stringent data protection requirements in the country in terms of protecting personal information, which is broadly defined. So personal information, for purposes of Massachusetts Data Protection Act, essentially means a name and some information like a checking account, social security number, credit card number, that can be used for identity theft. Pretty much every business in the world has this information, except maybe the drug dealer on the corner, but he's got other issues to worry about. So you have got to protect the security of that information, and if there is a breach, whether it's a breach from somebody online or somebody walks, the number of times I've walked into a client's office and there's a computer at the reception desk and nobody's sitting there and the computer's on. You can sit down, oh, look at this. Or what happened at a Boston law firm, some guy walked in, wore a business suit, everybody assumed he was a client. He started, every free desk he found, he started rummaging through the desk, walked away with client trust fund checks that he then wrote out and essentially stole the law firm's client money. But anytime you have that kind of data security breach, not only you have to report it to the state, you have to self-report. And that gets that's another publicity home run. But also Massachusetts is now looking at a Consumer Data Privacy Act that would be similar to California. So you got to get permission if you're going to sell data. Consumers have the right to opt out. There's a whole bunch of provisions there that you need to be aware of. And a lot of states are looking at this. Maine's looking at it, Nevada's looking at it, New York's looking at it. California has the act that they adopted, but they're still in the process of amending that act, so we don't really completely know what it's going to say at this point. So these are things that you're going to need to be aware of. When you put something in your privacy policy, make sure you do it. Make sure your employees do it. Make sure your contractors do it. So in the early days of not the early days of the internet, but sort of the mid-range days of the internet, when people started thinking about privacy, they started saying things like, we'll never sell your data. Oh, isn't that nice? And then Microsoft comes along and says, we want to buy your company. Oh, I can't sell my data. Well, if you can't sell the data, we don't want your company. Now, if I'm writing your privacy policy, I'm going to say one of the things we might do with your data is sell it if we sell substantially all of the assets of the company, or if the company goes bankrupt. That happened. Large consumer products company went bankrupt. The job of the bankruptcy trustee is to gather the assets of the business and to sell them off in order to pay the creditors. And what they wanted to sell was the consumer data. Federal Trade Commission says, au contraire, mon frère. You had a statement on your website that said you will never sell the data. So you're not selling the data. So you want to make sure that...
Why would a company do that? because if they go bankrupt and they're like an LLC or...
Well, they were doing it because that's what people wanted to hear and they didn't think through the implications. Now people don't do it.
of selling the data if they go bankrupt?
You put that in your terms of use. As long
Why
as...
would you want to do that? Like, why wouldn't you just let the data get erased and not get sold?
Well, you don't... Well, if you're bankrupt, you don't get to make the choice. If you file for bankruptcy, you lose control of the assets of the business.
Yeah.
The court appoints a bankruptcy trustee, and it is the job of the bankruptcy trustee to take those assets and sell them off.
But if it's in your privacy policy that you won't do that, and you can't change that section, you would protect your users even after you go bankrupt.
Well, then that would prevent the bankruptcy trustee from you selling the assets then.
Yeah.
But whatever you're going to do, whatever you say in your policy is what you got to do.
Because if you're bankrupt as a company, you don't really care if the creditors get paid back.
Oh, well, it depends on what kind of bankruptcy you're doing.
Okay.
There's two kinds. There's the kind where it's a reorganization, where you're hoping you're going to come out of bankruptcy and still be alive, in which case you care very much.
Okay.
And then there's the liquidation kind, where maybe you don't care. But
It must be like a noble way out where you
Yeah.
buy your data.
well, I'm not sure that people, make sure your employees do this. I just reviewed a contract where my client, and sometimes this was done, I think, out of a very good sense. So my client is a fulfillment company for an online seller. My client gets a contract. But my client also sells their own products through their own website. And the contract says, we will provide you with consumer data, which is data about our consumers. You will only use the data we provide you for purposes of filling the orders. So far, so good. Then the next sentence says, you will never contact our consumers. No, because if your consumer contacts us through our website, we're going to contact them. So, and I think it was not a case where they were trying to be unfairly restrictive. I think they just hadn't thought through all of the, and once we brought it to their attention, they were open to a fix. But you need to think all of the implications through. Reserve the right to amend your policy. It's sort of a standard. You read it at the end. It says, we reserve the right to amend the policy. Your continued use of this website means you agree to, because you don't want to have to then go back and say to however many people who provided you with any data, oh, by the way, we changed the website, the privacy policy in these 3 respects. Hope you like it. So you want to put that kind of a statement in there. Then, terms of use. Identify, as I said before, identify the business as a limited liability entity. Disclaimer of warranties and limitations on liability. Particularly if your client sells products over the internet, under the Uniform Commercial Code, there are certain warranties that attach unless they're explicitly disclaimed. This is where you do it. You put limitations on liability. In no event will we be liable for punitive damages. In no event will we be liable for the maximum amount we'll be liable for is anything that you've paid us in the last 12 months. There's a whole bunch of different ways you can do this. Reserve the right to delete content, but not edit it. So if you've got space on your website for people to post comments or third-party, any kind of content, and they start to post offensive or defamatory material, you just want to take it off. Because if you try what's happened is in some cases, the website owner has tried to edit it to make it less offensive, and then you can be sued as a public, if there's a defamation suit and the person who's being slandered still thinks the content is defamatory, you can then be sued. It's better to just delete it. And you want to just put the world on notice that you have the right to do that.
Does that extend to reviews for a product?
No. It depends on what you mean.
So, say I buy something from Amazon, I don't like it, I give it a bad review. could Amazon reserve the right to delete that review? Well, Amazon's a bad example, but
Well,
if I
it's-
buy a product from a mom and pop small business,
Right.
I review it there, can they reserve the right to delete my bad review?
It may be a problem for the Federal Trade Commission regulation. I'd need to think a little more about that. DMCA provisions, indemnification from content providers, which we've talked about. You can put in provisions that require them to consumers who are unhappy to arbitrate rather than sue you, which you'll see in a lot of terms of use, as long as it's reasonably disclosed and accepted. If it's deemed to be too hidden, it may not be enforceable. And then insurance. Okay. Again, as I said before, when you create a limited liability entity, it's a firewall. It can be breached a number of ways. One of them is if you don't have enough assets to cover potential liabilities. And a lot of startups, that's the case. You come to my office, I'm not a startup, but the hard assets in my office are furniture that I've had in the office for 30 years, a couple of computers that were obsolete 5 minutes after I walked out of Best Buy, books on the shelf that are more decorative than anything else because I don't read them, because I do all my research on the internet. So the assets of my business are insufficient to cover potential liabilities to my client. How do I deal with that? I have insurance. So you need to have appropriate kinds of insurance and appropriate levels of insurance, or somebody who has been injured by your client's product or service might be able to use that lack of insurance as a way to get past the limited liability entity and get to their personal assets. May be required by contract. So lots of times, and I see this a lot, small business, and we give them a first big contract, and it's really great. And then we read, the contract says, you're going to have, and I literally had this happen. The client had developed a software program, national company buys it, wants to buy it, and then we get towards the end of the contract and it says, you have to have errors and omissions insurance, you have to have infringement insurance, you have to have cybersecurity insurance, and the total amount of the cost of the insurance exceeded the amount of the contract. Not such a good thing. Also, if the contract requires insurance, you don't have it, that's grounds for voiding the contract. I was representing a couple of guys who were going to invest in a software company, and the owners of the company were saying, yeah, we have this contract, and it's going to be, we have to provide all of these services, and it's really great. And when I was doing my due diligence to look at whether the investment should be made or not, I said, well, you're supposed to have all this insurance. Where are the policies? Oh, we don't have it. They're not going to care. I said, well, that was one of many reasons my client did not invest in that company, because I said, what are you going to do when they show up? We want a certificate of insurance dating back to the first day of the contract. So when you do, you check for infringement. Would be a separate coverage. It's not part of your standard coverage. When you were asking about ADA compliance, it would typically be found in an employment practices liability insurance policy. Privacy and data breach recovery coverage. Very important these days. Any of the, a data breach can put you out of business, put your client out of business, put you out of business as well. So that's it for my presentation. And here are some resources. We can make the slides available, so. Yeah.
I have a question for you.
Sure.
This is about genericized trademarks.
Sure.
So we work with WordPress. WordPress is an open source CMS.
Mm-hmm.
Automatic, founded by Matt Mullenweg, had the original WordPress trademark. It was given to the WordPress Foundation. They do a pretty good job at enforcing, like if somebody has like WordPress service, they'll sue them, the smaller companies. But larger companies that offer WordPress products like managed WordPress hosting use it, and it's not really enforced. Like, is there any risk there long term?
You know, there is a risk. There's not necessarily that it becomes generic, which is a separate issue, and I'll touch on that in a second. But if, as I said before, if you fail to enforce, you can lose your right to enforce. Now, one way people deal with somebody who's using, infringing with the mark is to simply say, pay me some money and I'll give you a license to continue using the mark. So when you see somebody using the WordPress mark, it may not be that they're infringing because WordPress may have gone and given them a license. That's a sort of behind the scenes thing that you don't know about. Generic is, as I said before, when the term is no longer used as a mark to identify the source of goods or services, but it identifies the product. And so, for example, so IP lawyers worry a lot about this. So if you want to get a lawyer from Xerox really upset, say, I'm going to go make a Xerox of this. And they're going to say, no, it's a Xerox brand copy. Because aspirin was once a trademark owned by Bayer. And it became generic. Now aspirin you don't associate aspirin with Bayer, you associate aspirin with the product. It no longer serves as a trademark. It no longer identifies the goods or service. That's why you hear the folks at Johnson & Johnson talk about Q-tip brand swabs as compared to Q-tips.
Kleenex, too.
Exactly, exactly right, exactly. Somebody from that company is going to say Kleenex brand tissues, not Kleenex.
And yet, isn't that where every company wants to be?
Well, yes and no. I mean, you're absolutely right. You want to have that universal recognition, but you want to have it in the right way.
Yeah.
You know. So, any other questions? Oh, you're still awake. That's something. Thank you.